Hi there, this is Alex Woods. I'm a civil litigator specialising in the field of financial mis-selling, principally payment protection insurance claims, complex payment protection insurance claims. And I just wanted to talk to you today about the risks of repossession and how to deal with payment protection insurance on a mortgage. Now, the first thing to say generally is that payment protection insurance was sold in reasonably large quantities on top of mostly second charge mortgages and not so many on first charge mortgages. Certainly I've not come across any first charge mortgage PPI. And I should say that they are something of a different animal from your normal payment protection insurance claim. And not only are they far more complex than a conventional payment protection insurance claim, and you'll probably be ruining the day if you're a consumer listening to this and you've got a threatening letter from a bank's lawyers, you'll be ruining the day that you ever signed off on your home being included as security on a loan where payment protection insurance has been missold. Now, I'm just going to tell you the story of my involvement with payment protection insurance on second charge mortgages, and then I'm going to deal with the legal issues that arise, and that's going to be more of a legal and a sort of pseudo-professional insight into the issues, and then I'm going to conclude with the next steps and what it is that you as a consumer can do about it and what you should do about it if you are threatened with repossession proceedings and you have believed you've been missold payment protection insurance. So the first thing to say is something over 2 years ago now, I happened to be in Croydon County Court, and I was there with a client on a second charge mortgage payment protection insurance claim. And we'd finished the hearing, and I was sitting in Croydon County Court with him. And there was a married couple who tapped me on the shoulder and said, "Excuse me, are you a solicitor?" And I immediately thought, here's a couple of freeloaders wanting some cheap legal advice from me. And anyway, my client kindly said absolutely there's no problem, because obviously I didn't want to interrupt the client conference that we had completed the hearing. And so they then told me their story. And I was surprised at that time. I hadn't dealt with a case of this complexion before. They'd had a Black Horse loan, and they had been sold, they'd wanted, but they'd been, nevertheless they'd been missold a payment protection insurance product of around about £8,000 on top of a £14,000 loan. So an extremely expensive payment protection insurance product. I've since learnt that Black Horse, who was the lender in this case, Lloyds' subprime non-status lending division, a lot of the big banks during the crazy boom times bought the profitable non-status lenders, the subprime lenders, and bolted them onto their own big existing, conventional retail arms. And they had actually made a claim on this payment protection insurance after he was a tradesman and he'd had an injury at work, and she had pretty much simultaneously lost her job. So they'd made a claim on this insurance, and they had to wait 10 months, 12 months for it to be adjudicated, and then the claim was rejected. Subsequently, they were, during the course of those 12 months, needless to say, they defaulted because he'd had a serious injury at work and she'd lost her job. During that 12 months, they'd been told that she couldn't claim concurrently. She couldn't claim at the same time. They had to wait for him to have his application on the insurance adjudicated, and only then could they proceed to put in an application on the insurance for her. So, I mean, just absolutely a breathtakingly incompetent piece of client care by Black Horse on this occasion. And right down to the fact that the reason they finally rejected the complaint was because hadn't got a certificate from his GP. And in fact, he had been referred straight to a plastic surgeon over a crushed thumb. So, I mean, you'd be amazed, wouldn't you? Well, you probably wouldn't, because you're someone who's watching this video and it's just happened to you. I saw on the lists of Croydon County Court, Black Horse's name peppered all over the lists. That was, you know, repossession day. Anyway, they told me the story and I was absolutely astonished. They went into the hearing and the judge, quite grudgingly actually, because the judge has usually got a dozen repossession applications to go through, and in most cases, probably 95% of cases, it's just people who haven't, you know, who failed to meet their payments on their loan, and some of them haven't even turned up at court. So he's usually got a hat on that's quite negative towards the debtor or the consumer. Anyway, in this case, they managed to. I told these clients what to say to the judge in court, and I wasn't in a position to represent them at such early notice. Wouldn't have been appropriate. And then he gave them time to instruct a lawyer and to prepare their advice, to prepare their case. And they had been through a number of different routes in order to try and get some help with this. They'd been in touch with the Law Society, who hadn't been able to refer them to a specialist solicitor. They'd been through Citizens Advice Bureau that hadn't really been able to get to grips with the complexity of their situation. And they had drawn a blank, and that's why they had turned up on the day with a letter which they'd written to the judge. Subsequently, we defended the claim for repossession. We counterclaimed for missold payment protection insurance, and perhaps 18 months later, perhaps less, we had settled the case. But it was a fight, make no mistake. And you know, this is something that no way was the bank's own complaints process able to deal with this, and nor would the Financial Ombudsman Service been able to have dealt with this type of case either. And it was just a couple of weeks ago, to bring you right up to date, because that case was, as I say, I say 2, perhaps even 3 years ago now. Just to bring you right up to date, I have had a recent inquiry from a client who, down in the southwest of the country, was about to end up in a hearing in a pretty similar situation with the same lender, in fact. And he had struggled to find specialist legal advice in this area, and he is quite a professional and organised man, with seemingly a quite established in his profession, a more senior gentleman, and once again I was somewhat surprised at what had taken place, and so I gave him instructions about what to do, and the judge has given him. The judge was far more sympathetic to his situation. Perhaps the payment protection insurance scandal has caught up with the judiciary over the last 3 years since I was there, and he has given him plenty of time to instruct a solicitor and prepare his defence and counterclaim for missold PPI. Now look, so there's the story, and that's why I felt it was important to talk to you today about repossession, because I think there must be dozens, hundreds, thousands of people out there who don't know what to do, who are confronted with the repossession of their home off the back of missold PPI. Now, to come to the quasi-legal part of my video bulletin today, what you will find is that a lender will either 3 years ago it was objecting entirely to the fact that payment protection insurance had been missold. In the more recent situation, it was actually a case where they had refunded the payment protection insurance after a complaint had been made a couple of years ago, but had set it off against the debt, hadn't given the client cash, hadn't asked for his consent, had just done it, and had also failed to pay out on a claim previously, and hadn't paid as much compensation as the client felt he was entitled to. So, well, I can see how the situation somewhat changed now that everyone's aware of the mis-selling of payment protection insurance. The issues have shifted slightly. Now, the sort of the legal point, or the quasi-legal point, if you like, is, and I spoke to the other side's solicitors on this particular recent case, is that from where they sit, from where their solicitors sit, and they've been instructed by a bank who have told them that this payment protection insurance claim has been settled, and we don't know why the bloody client isn't keeping up their repayments, and we want you now to get heavy and threaten repossession proceedings. And the solicitor in those circumstances, perhaps with limited papers, doesn't know what the other side's case is, simply takes a view that, hey ho, I'm going to now draft a letter to the consumers, to the defendants, and I'm going to ask them to agree to perhaps a suspended possession order, or some sort of order or wording in a letter, perhaps endorsed by the court, to say that, fine, we will agree to a monthly repayment of X. In this recent case, the amount was high, but the client said he could afford it and had agreed in principle to it. In fact, it even paid the first instalment in advance of the hearing. So the lawyer will say, well, look, you will sign up to pay X, and the moment you default on paying X each month, we are entitled to repossess. Now, this is a really important issue for consumers and lawyers working in this sector, because it is quite a draconian measure in circumstances where a client feels that his payment protection insurance claim hasn't been adequately assessed and redressed, and and where he is prepared and willing to come to some sort of arrangement for some sort of a repayment plan, but the temptation for the banks is, who are morally neutral animals, big corporations, afraid of what's happened over the recession, trying to protect their balance sheets, shore up their balance sheets, etc., etc., taking sort of steamrolling claims through and trying to get the court to add some sort of an order in order that they can repossess a home should a consumer fail to meet an agreed repayment date. So now what the solicitor the other side said to me was, look, leave aside payment protection insurance, and you may find as a consumer that if you do find yourself talking to the other side's lawyers or to the bank in question, they will say to you, look, you look at the wording of the loan, you have signed to have this loan secured on your property, and if you read the small print, upon default, we are entitled to immediately repossess. So they feel as if they're being fair and indulgent towards the consumer in not triggering that default clause in the contract secured on the home, done, however many countless years previously, the small print. And it kind of narks them and niggles them or needles them that you're throwing in this irritating little payment protection insurance defence and counterclaim. They'd like technically to argue that it's not a defence, it's an entirely separate claim, and that then allows them to repossess the home and to say, fine, to the courts, we accept that there may be an issue about the payment protection insurance, but it's nothing to do with the clients having defaulted on their loan. Look at the small print, it's secured on the property. So you see that it's quite important to be thorough as a lawyer and to know, have some understanding of these issues if you're a consumer threatened by repossession proceedings. That you've got to be careful that lawyers for the banks don't sort of drive a wedge between the repossession issue and the payment protection insurance issue. You've got to be quite strong and plead your claim, your defence and your counterclaim properly, that the mis-selling of the payment protection insurance has contributed or is associated or is entirely relevant to the issue of the defence to repossession proceedings. And this is no more nor less than is often the case. Second charge mortgage PPI is often a very substantial part of the entire indebtedness that the client is suffering under, and can ramp up your payments, you know, from 200 to 300. I mean, I've seen nearly 100% in one case, £350 a month. And if you've defaulted and you're struggling, you know, it's hardly a surprise that you would want to deploy a defence of a mis-sold payment protection insurance product. So there's a legal issue. There's one secondary legal issue, which is perhaps of a more, which is really a finger in the air issue, and you have to, you really do as a consumer have to assess to what extent this applies, and that is arrears. Now, it may transpire, I don't know, I know nothing about the individual circumstances of this recent case yet, that the client has been in substantial arrears, such that there is a strong case that, you know, it would be slightly taking the mick to claim that the payment protection insurance was the reason for causing the client to default on their repayments, where a payment protection insurance redress has already been paid. So there's this sort of ancillary issue around these types of cases where the client is in arrears. I'd rather have a client who wasn't in arrears, whose account was squeaky clean, but it very rarely happens because the payment protection insurance has often inflated the monthly repayment and has therefore contributed and been a not insignificant factor in the client's missing their repayments. So that's a secondary issue, and it's very difficult to know how to advise a client on whether to robustly defend and counterclaim on second charge mortgage, second charge PPI, or whether to try and arrive at some sort of a settlement. But in any event, and I now conclude with the steps that consumers who face with these sorts of cases should bear in mind. In any event, you should at all costs not allow a lender or a lender's lawyers or the barrister in court, and they can be very robust about this, not allow them to stick some sort of an order or get some sort of charging order, would be really bad news, or some sort of endorsement from the courts that they're entitled to repossess if you miss one of your repayments. You should try and avoid doing that. You should simply ask the court, look, it's complicated. I do feel down here that there's something not right about the amount of payment protection insurance refund I've got. I don't feel the claim's been properly addressed. There are these complexities involved. I want time to take legal advice and then to come back to the court with a defence and potentially a counterclaim. And you should be quite robust, and I think that you will find now in today's climate that the judiciary will be more sympathetic to you. So that really is the most important thing. Now, lawyers cost money, I know. I tend to require some money on account initially, otherwise I am a no-win, no-fee lawyer. And you should, whether through me or through somebody else, you should at least get a little bit of advice from a lawyer who can take the statement and go through your paperwork and say, look, you know, I think you should actually accept some sort of endorsed by the court to repossess if you fail to keep up with your agreed restructured loan repayments, because you've been so badly in arrears that you can't really blame the payment protection insurance in this case, or no robust defence is appropriate here. So that's the final thing I'd like to say is that you'll save yourself money if you've properly prepared your case beforehand. And by that I mean simply getting all the paperwork together, having a note of any hearing, and having it all in chronological order with the most recent letter or the most recent attendance note of a hearing or telephone call at the top. If you've got all that in nice apple pie order and you supply that to the solicitor, he will then be, hopefully, he will then, it'll take him a lot less time to take your instructions over the telephone and to give you some advice about whether to fight or not, really, to fight or settle. It could cost you 500 quid, 250, it could cost you 1,000, but at least you will then, if you feel strongly enough, you should do that. You should invest that amount of money, and then you at least will have a better view of the strengths and weaknesses of your case, and know what the next step forward is. Okay, thank you very much indeed for listening to that video, and don't hesitate to post comments on the site, or indeed to email at info@redwoodlegal.co.uk if you have any particular specific questions. This is a general advice type site and a general advice type video, but I hope you will see I've tried to make it as relevant as possible, as I possibly can, and relate it to actual real life cases. Many thanks for your time. Goodbye for now.